in tandem.
Lord,
Either everything remains together or everything perishes together.
Lord, then let everything perish together. There is the government of India's case that there were impediments in running the administration of the state for any reason, except national security and some violence. They have not given any other reason also. So what this has worked, it must continue to work. Now, why the House carried it? Today's House has no moral or constitutional authority to undo this just because it has a majority. It's an extraordinary, I must say, legislative act, parliamentary act. It's neither legislative nor constitutional. It's not a constituent power. Question is, what is it that was not supposed to have been agreed, a promise?
If the power under the proviso to clause 3 has exhausted itself, then equally the power under the 2 provisos to clause D has also exhausted itself. In which case, how do we explain the exercise of that power for 64 years?
Looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it. Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of Sub-Article 1. No difficulty about it. Question is, can you repeal it? Can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist. The modality for exercise of the power under 370 bracket 3 is a different issue, which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power.
And there's no power to any of the COs.
What is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues, lordships are right, that time and again, Government of India is, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But, it's one thing to continue 371 and it's another to repeal 373. That's the difficulty. Nobody is not saying that presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's
you got the point. We'll move on.
Now just see.
Just 1 minute. Just
73 is something which is left to the will of the people. There is no difficulty. Government says.
Then what remains? If everything under the constitution can be made applicable by exercising the powers under D.
No, it needs consultation and concurrence.
That's what if with the concurrence of the question that is being put.
No difficulty. It can be undoubtedly, but the power of removing Article 370 is disappeared.
Is a different power.
That's an independent law. And government union in its affidavit has stated that all provisions of articles of constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so. There is no doubt that 370 has worked beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in running the administration of the state for any reason. Except national security and some violence, they have not given any other reason also. So this has worked, it must continue to work. Now why it should continue to work, please see Professor Dr. Iyengar's statement. PDF volume 8, page 1175. And House carried it. Today's House has no moral or constitutional authority to undo this just because it has a majority. For the people of Jammu and Kashmir, this was the essential feature of the constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir. Because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it. Sayajirao. Transitional governments.
So therefore, the concurrence of the government also in terms of the first proviso to clause D was till the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being.
No, Lord, that may perhaps...
What he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case,
3
really speaking,
that it was left to the Constituent Assembly, otherwise it makes mockery of the provision. If now somebody else, complete stranger, were to decide, the governor will make a recommendation, or the president will make a recommendation, or parliament will resolve. Here what they have done is that parliament resolved. It's an unusual procedure. It's neither a constituent power nor a legislative power that parliament exercised on 5th and 6th of August 2019. Parliament resolves that president may issue an order under 373, abrogating it. It's an extraordinary, I must say, legislative act, parliamentary act. It's neither legislative nor constitutional. It's not a constituent power.
Reading right.
Advice that because state is under president's rule, parliament therefore is constituent assembly or legislative assembly, and therefore this could be done. But it can't be, because that has come to an end.